Please be seated, everyone. Good morning. Looks like we have two criminal cases set on the docket this morning. First one is Bondsteel v. People, and we're set for an hour. Looks like both counsel are ready. Mr. Hare, why don't you start when you're set?
Morning. May it please the court. My name is Andrew Hare. I represent Jim Bondsteel. And I'm going to address the first issue that the court granted review on with respect to a preservation question in the area of joinder. In short, a defendant doesn't waive his ability to raise joinder on appeal if he or she does not renew a joinder objection during trial, at some point during trial, whether in the middle of trial, close of evidence, what have you. Really, this particular issue is driven, I think, by this court's recent decision, relatively recent decision in Rediger, which really kind of outlines preservation framework, if you will, in Colorado, ranging from invited error to waiver, which is an intentional relinquishment of a known right, to forfeiture, which is also subject to or akin to plain error review, where a defendant doesn't object. In this particular instance, well, before I get to the actual facts of Mr. Bondsteel's case, really, again, Rediger kind of outlines the current and prevailing view of preservation requirements in Colorado. The, if you will, older, decades-old view under Albu, Peterson, Baker, those seem to have been driven by the old Rule 33, which at the time had required a defendant, in order to raise an issue on appeal, to raise the claim in his motion or her motion for new trial. And so in that sense, that way it was formally, as a matter of form, preserved for appellate review. That was done away with. We have rules, both under rules of procedure and rules of evidence, 103, criminal procedure 51. A defendant, when he or she makes objections to the trial court's rulings, or in this particular instance, in Mr. Bondsteel's case, a very thorough and full and fair consideration of the funds of evidence at issue with respect to joinder, defendant doesn't need to re-object and renew his or her objection. And so I think in line with both Rediger and understanding the rules as we know them today as they apply, a renewed objection is simply unnecessary for purposes of review. So Mr. Bondsteel didn't waive, he didn't intentionally relinquish his right to raise joinder on appeal. Certainly under these facts, under this case, that's an untenable view, but
Mr. Hare, can I stop you there? Good morning.
Morning.
Practically, if the motion is renewed at the end of the people's evidence, what's the remedy? If the judge goes, you know, you're right, what would be the remedy?
well, I suppose if under the court would have to grant a mistrial, or I mean, that would be the only remedy really, would be to end the trial. If the court had reconsidered and thought, I made a mistake in a second reconsideration, which again, that's the language in Albu, is it gives the court a chance to reconsider its ruling. Well, again, the rules don't require a defendant to re-raise objections in order to effect this reconsideration to then also preserve the claim for review. And the absence of doing so certainly doesn't waive it as we understand waiver today.
Thank you.
Mr. Hare, are you effectively asking us to overrule Albu in that line of cases?
I think it's maybe bringing them up to date. Again, I think that you know, back in the 70s and 80s, I think there is this carryover, spillover with regard to, I mentioned Rule 33, the old 33. And there's references to, in Albu, to the defendant, you know, or excuse me, defense counsel strategically deciding not to say anything if you will, or not raising certain claims, which again, that's kind of an erroneous understanding again of our current framework of preservation. So to the extent that it employs waiver inappropriately or incorrectly, yes. So it really is bringing this area of law, joinder and severance, 8, 13, and 14 kind of up to speed into what we understand these current preservation rules to be in Colorado.
Can I jump in, because I think I'd like to make sure I understand the nuance of your argument. I see a distinction between what's required to preserve an issue versus what are the consequences of failing to preserve that issue. And your comments about how Rediger has clarified the distinction between waiver and forfeiture, I think deals with the consequences of that failure to preserve. So help me understand, are you saying that Rediger means failure to preserve the issue would still allow a plain error review?
Correct.
Okay.
In other words, if under, especially the cases that I've cited, I believe it's Bagby out of the 10th Circuit, if a defendant didn't object at all, didn't say anything about joinder, let's say, the prosecution moves to join, just giving a hypothetical. Prosecution moves to join, defense counsel's silent, doesn't say anything, comes up on appeal. I think that, and the court rules, I'm going to join the cases, perhaps make some findings of fact, conclusions of law. That issue is reviewable under Colorado law. There's not an intentional relinquishment of a known right. That's a classic example, a classic error that would be raised, plain error review.
Okay, but to me, that doesn't necessarily address whether, in order to preserve the issue, one needs to renew that objection at the close of evidence.
Well, then we're getting into the nuances of what are the rules required. 8, 13, and 14 are silent about having some exception or some carve-out requirement. The Court of Appeals cited to a Tennessee case and said, look, the defendant in Tennessee case was foreclosed from raising this claim on appeal. Well, if you go to the Tennessee rules, you see that the rules in play require, similar to Colorado's old Rule 33, for the defendant to raise that again in the motion for new trial. But we don't have that, so we have instead in place 103 and 51, which say you don't need to renew your objections in order to have the court reconsider. If there were something, if the court wanted to amend the rules to require an additional objection or a reconsideration by the court regarding its ruling, it could do that. But these rules don't provide that. And again, when we look at the current state of the law with respect to preservation and these rules, there isn't this requirement. There isn't that requirement of a renewed objection.
Okay, I was just trying to distinguish, or at least keep separate, the consequences of the failure to preserve and what are the requirements to preserve. And I don't know that Rediger necessarily addresses the preservation piece. Rediger would address what happens if it's not properly preserved.
I don't disagree with that, but the requirement of a judicially created, I think really what Albu and Baker and Peterson are alluding to, this and misusing, if you will, the term waiver. Those cases, losing my train of thought, excuse me,
Well, maybe perhaps to get you back on track, let's focus on preservation and your strongest arguments for why preservation is established merely by raising it at some point. You don't need to actually re-raise that issue at the close of evidence.
well, essentially of the plain language of the rules, there's no carve-out. The genesis of this additional requirement, again, it stems from an old archaic rule under Rule 33. There was the notion that you had to reestablish or reconsider and have the court reconsider rulings in order to have them reviewed on appeal. That's simply no longer the case. And so there is this, the genesis in Baker, which is pre-rules of evidence and pre-rules of procedure. You have this carryover, which again, it's kind of tainted by a case at a time which was informed in a different way. But that's no longer required for preservation purposes.
Thank you.
So if I may follow up, and first of all, congratulations on coming out of retirement. It was quicker than Brett Favre, I think. Just want to make sure I understand what we do with ALBU. It sounds to me like, really coming back to Justice Hood's question, do we need to overrule ALBU, or is your position ALBU was effectively superseded by the amendments to the rules?
Well, I think that's maybe the softer way of going about it.
I'm just figuring out how we would write, if we're going to write this, and if we were to agree with you, what we would write.
Well, I think in line with my discussion of the history of Genesis and where this language came from, and so it would help to understand the history behind it. I think in terms of why the court is coming to this conclusion that we're going to deal with a different operating framework, and so it just clarifies, both the rules in play and the state of the law in Colorado. And I think it also brings kind of a common sense approach to the litigation of this issue in particular. And I think Gross, made the right call, and it made common sense at the time in terms of not requiring a renewed objection. But in any event, I think that's one way of approaching it.
Okay. Go
Oh,
ahead.
I'm sorry, go ahead.
I was going to take it in a different direction, so.
I just wanted to follow up on ALBU, though, and the question of how we phrase it. I didn't go back and look and see exactly the timing of that, but the case itself was like in the mid-'80s. So unless it dealt with a crime that was committed long before, at least we'd have to be saying, if we agreed with you, that ALBU probably made a mistake and carried forward something after the rules had already changed. Is that right?
I agree, and also the use of the term waiver. I think even the Court of Appeals, Judge Webb kind of foreshadowed that the language in ALBU, one of the reasons why Judge Webb did not apply retroactively his different resolution, if you will, with regard to preservation, was that the use of the term waiver did not seem to conform with what the courts now, the Colorado courts now consider it. So, yes, I think that there seems to have been kind of a arguable misuse of terms, or at least a different use of terms at the time that maybe it didn't have the same meaning, as well as this connection with history in Colorado regarding renewed objections and preservation in that respect.
I was going to just take in a slightly different direction. I fully understand the argument you're making about ALBU, but let's say we disagree with you and conclude ALBU remains good law. I'd be interested in your response to Mr. Kozaleski's proposed rule. He suggested that whether you have to renew sort of depends on the nature, bless you, the nature of the motion. If effectively you're arguing joinder, if I misstate him, he'll correct it. But I think his argument was if the motion or the objection was effectively joinder was wrong from the beginning, you're essentially making a Rule 8 argument, no need to preserve. But if you're arguing prejudicial joinder, then you do. I'd just be curious he'll tell me if I got that wrong, but I think that's effectively what he proposed. I'm just interested in your response to that if we were to disagree with you about ALBU.
Well, as regards Mr. Bondsteel's case, I mean, the case began with the state's notice to introduce 404B evidence. So inextricably linked in Mr. Bondsteel's case is the evidentiary consideration and the evidentiary narratives of both cases. And that was completely flushed out. It was the state who sought to proceed with a 404B consideration. And there are dozens or perhaps a half dozen or so cases in Colorado that talk about the interrelationship or the relationship between joinder questions and then 404B in deciding prejudice questions. And the state is seeking, as I understand it, they're trying to divorce the question of prejudice from the initial question of joinder under the three prongs under Rule 8 from the rest of the actual equation, which Rule 13 provides that subject to Rule 14, the court can authorize a joinder of cases, but Rule 14 deals with prejudice. So in this particular instance, the state told the court, told the parties at the outset, we want to proceed with 404B first, the motorcycle case, into the Signal Mountain Trail case, and we want to have a full hearing on it. They had a full, virtually all-day hearing on this. They explored both the motorcycle case events and then the Signal Mountain Trail case. So that was proposed by the state. That's the way it proceeded in order to address ultimately the question of prejudice, I believe. Now, it had some overlap. There's overlap between 404B and prongs within Rule 8. But nevertheless, that's really the gist of proceeding with 404B is addressing prejudice. So, and the fact that it's intertwined, if you will, with one of the prongs that's later the basis for a Rule 8 joinder doesn't mean that there's anything incorrect about it, or you know, as I said, we're not really, we didn't really complain about the process. It was more about the substance of the claim. So the prejudice prong is an essential part both under the plain language of the rules and under Colorado case law. The court does not have the authority, the discretion to join without having considered the question of prejudice. The rules explicitly provide that. So that's what happened here. We disagree with the court's results on a couple of different levels with respect to both the motorcycle case into the Signal Mountain Trail case, but also in addition, as defense counsel Buell and we've argued consistently, the Signal Mountain Trail case into the motorcycle case. Because in this particular instance, the state thought, the prosecution below at trial, thought once we were able to convince the court to introduce the motorcycle case into the Signal Mountain Trail case, we can ask for joinder, and the court joined based upon only not reciprocal admissibility, but just admissibility of the three incidents in the motorcycle case in the Signal Mountain Trail. Defense counsel was correct. That's an erroneous understanding of basically the body of law that talks about cross-admissibility, reciprocal admissibility with respect to joinder vis-a-vis prejudice, the prejudice prong under Rule 8 and 13. The court thereafter really was discussion. The state in response made a somewhat laconic offer regarding why the Signal Mountain Trail case, which was by far and away the more kind of egregious or violent, if you will, event, and why it was admissible into the motorcycle case, and also conflicted with their rationale, their evidentiary hypothesis as to why the motorcycle case was admissible in the Signal Mountain Trail, which was that this person was escalating their behavior, and it was relevant to questions of motive, intent, and modus operandi. And so defense counsel brought that to the court's attention. The court actually did acknowledge that the Signal Mountain Trail case, with respect to introduction into the motorcycle case, really was unnecessary, especially, not unnecessary, but it limited or indicated its, that the probative value was obviously less given these evidentiary hypotheses that the state had offered. The state, one of the issues was modus operandi. This was in line with the identity issue, which the court in its final written order acknowledged was a central issue in the case. Identity was an issue. The state had in their argument regarding the motorcycle case into the Signal Mountain Trail highlighted what they believed to be similarities such that it rose to the level of modus operandi. They persisted in that. They argued the modus operandi and escalating hypothesis and closing argument in the case, and that became a really critical factor for them and in the court's ruling. The state apparently has abandoned that now, and they've pulled back, and I think in line with realizing they don't have it, this case is the antithesis of modus operandi. It simply doesn't, the requirement of significant features or signature features, distinctive, remarkable similarity, that kind of language, which is in line with modus operandi, it simply doesn't exist in this particular case. And so then the court pulls back, and when you look at the order confirming joiner, indicating that the court had already joined without having actually considered the reciprocal admissibility of the Signal Mountain Trail case into the motorcycle case, it reduces the so-called similarity of these cases to these surface level findings of outdoors, it involves women, a weapon was used, and the fourth one doesn't even really relate to the same or similar character prong of Rule 8 because it deals with the temporal issue, which isn't relevant to that particular question. But in any event, this is really in this particular case, the problem, the error is that these are not cross-admissible cases. First, it's not admissible, the motorcycle cases, into the Signal Mountain Trail case. The range of similarities that the state offers are so broad and vague, or broad, that it would include any number of potential other offenses. And compare that to the range of dissimilarity is striking. That's what's striking about this case, are the dissimilarities between these two events. You know, some of these cases, like George, if the court looks at George, there's a nice chart where the court lays out the sexual assault on child counts that are joined. And it provides critical facts and relevant facts that show real true similarity, multiple instances of similarity vis-a-vis the allegations. That's the kind of thing that would warrant a finding based upon similarities that could ultimately be relevant to and independent of the intermediate inference that the person has a propensity to commit this kind of crime and where the probative value would not be outweighed by the prejudicial value, but not in this particular case. And so that's both with respect to the motorcycle case into the Signal Mountain Trail, but particularly the Signal Mountain Trail into the motorcycle. Their rationale for admissibility evaporates. It doesn't exist really in the real world. And so that's why in this particular case, it should have been 2 trials. We would still object to the admissibility of the motorcycle into the Signal Mountain Trail, but certainly the Signal Mountain Trail should never have been part and parcel or considered by the jury in the context of the motorcycle cases.
I guess what I struggle with, Mr. Hare, is the abuse of discretion standard. So reasonable minds could differ. You know, you're not flatly wrong, but it's an area in which trial courts get a lot of latitude. So what's your response to that? I think I can anticipate what it might be, but why don't you go ahead and articulate that?
And if Justice Hood wouldn't mind me glomming on, particularly in light of 1610 was a 301, where the legislature pretty much said, you know, we welcome other acts evidence in sex assault cases.
Well, I think ultimately, and I agree that the statute exists and there is a favoring of admissibility of evidence in sexual assault cases when it can be done. However, that hasn't superseded the prongs, 3 and 4 in SPOTO, and this court has been consistent about how these kinds of acts, and keeping in mind that there's a disparate, again, getting back to the differences, there's a disparate and a significant difference between the motorcycle cases and this event that occurs up on the Signal Mountain Trail. These are fundamentally and their nature and character are different. And the Signal Mountain Trail case is particularly egregious. And it's particularly different from the motorcycle cases. So while the court has discretion and a court has the statute that provides some guidance, Rule 404B still provides under prongs 3 and 4, under SPOTO, that courts have to be aware of and cognizant of that facts like these, especially the Signal Mountain Trail case, will have the tendency to create hostility in the minds of the jury, overcome whatever common sense that they might otherwise apply. The state relies upon the multiple counts instruction. Really, that instruction isn't an evidentiary instruction. It limits their ability to consider whatever evidence they want to consider. It just tells them that they have to, when they make a decision about any count, they make that decision uninfluenced by their decision on some other count. But that doesn't limit their ability to consider the evidence as a whole, which is exactly what the prosecution said this evidence was admissible for and exactly what they argued below. So when we use in this particular case, when the state refers to the escalating behavior and the modus operandi, it really is asking the jury to consider the propensity and the very different conduct in these cases to decide each of them. And so I believe that while the court has that discretion, there's a limit to the discretion. And again, the surface level similarities that the court finds in its order confirming joinder should be troubling, that this is all that's necessary, according to the state, to join cases. And part of their argument is without reference to prejudice. But assuming the prejudice prong is considered, which it should be because the rules require it, these surface level facts should not, particularly in a case like this, where they're so disparate, provide enough to allow joinder and allow a court to have the discretion to join cases like this.
Mr. Hare, I'm sure you want to save some more time for rebuttal, but let me just ask you one more question about the prejudice piece. You really focused on 404B, but before us is a question of whether the joinder here was prejudicial. What do we do with the fact that Mr. Bondsteel was acquitted on 5 counts? There was a conviction of a lesser included. One of the factors on prejudice is whether the jury could separate the law and the facts. Those facts would suggest that they could. Could you address that?
Well, I think I cited some authorities that talk about the spillover effect, and that the rationale that because the defendant is acquitted of some and convicted of others indicates the jury's ability. But on the other hand, the same rings true that the jury would have acquitted of all of the counts in the motorcycle case had they not been tainted by and had to consider this egregious event up in the Signal Mountain Trail case. The majority of those counts that you refer to were with respect to EC, one of the counts in the motorcycle case. Not sure of the explanation for that. The testimony is what it is, and so not sure why that occurred. But the position that we take is that that rationale simply is equally possible that because of the spillover effect, Mr. Bondsteel would have been acquitted of all of those events had these cases not been joined. I see I have about a minute and a half left. I'd like to reserve that time.
Mr. Kozlowski.
Good morning. William Kozlowski, registration number 37824 on behalf of the people. I'd like to start with kind of an overview of how I think these rules work, and I think that helps inform the preservation/waiver how those questions are answered. I think that it's important, no matter what this court decides, to make clear in this opinion that Rule 8 and Rule 14 are distinct. Obviously, they're distinct rules, but they are distinct claims that a defendant can make. We talk about joinder and severance. Well, joinder and severance are different things. Joinder, under Rule 8, is whether the charges can be legally joined in the first instance, and that is a matter of law. And Mr. Hare's been discussing prejudice a lot. If you look, I think this court should look to the federal cases that apply similar rules. Prejudice isn't a factor in the analysis of whether Rule 8 has been satisfied. It can be a factor of whether it's reversible, obviously, because it has to go to harmless error if there is error. But the question of whether there is error or not has nothing to do with prejudice. It's just whether the language of the rule has been met. And we're not making any assertion that a claim under Rule 8 has to be renewed at trial, because it's purely a matter of law based on in federal courts, the charging documents. But here, it's a very preliminary determination of whether the charges can be joined.
And does Rule 8 come into play here only because a motion to join under Rule 13 also has to comply with Rule 8?
Yes, I think that's the only, in this case, the people moved to join, and under the provisions of Rule 7 or Rule 13, a court essentially has two questions at that point. Can these be joined in the first instance? And if the answer to that is no, then the judge cannot join them, whether he thinks it's a good idea or not, or whether it would be prejudicial or not.
So you said two questions. So the first is, are they something that could have been joined originally? And the second is, but nevertheless, are they prejudicial?
Correct.
Okay.
And
So how do we separate those? I mean, I am intrigued by the rule that you propose, obviously, but how do you separate those in a case like this, where the prosecutor's motion really was, first, their evidence is cross-admitted, it was a 404B motion, and once the prosecutor won that, then the prosecutor said, now join. I mean, how do you distinguish that? I mean, it seems to me under Rule 13, in fact, your rule results in you always have to renew the objection, because prejudice is always part of that analysis.
well, I think, Your Honor, I think you're right. In this case, it largely does overlap, and it is the same motion. But I also think that that's a product of this distinction not being made. I think taking the Court of Appeals cases over the last 20 or so years, and a case eventually said it in Butson, is that you have to satisfy 404B for Rule 8 to be met. Well, you don't need Rule 14 if Rule 8 means 404B, because it will always, if that's what Rule 8 means, there is never any prejudice. Rule 14 doesn't mean anything. So I think where it comes into play is a case where you had 3 or 4 of the same crime committed at different times that didn't have cross-admissible evidence. A judge at that point can say, okay, these can be joined under Rule 8, but I only have to address prejudice under Rule 14.
So I'm just trying to play this out. So under Rule 8 on the hypothetical you gave, the prosecutor could charge those 4 separate events in one information.
Correct.
Fine. And then it's up to the defendant to move to sever if the defendant chooses to do that. The other scenario is the prosecutor charges in 4 separate informations. And in that case, then you've got to prove the prejudice, right?
Correct.
To join.
Yes, I'm not disputing that at all. But, maybe it's best exemplified by this court's Brown case. A defendant can move to consolidate. And in the Brown case, it was a series of auto thefts, and there's no indication of whether it was cross-admissible. But that defendant wanted to do that to avoid habitual sentencing. And the court said, yeah, I'll go ahead and do that. And the people appealed and said, we want to get habitual sentences. And this court said no. But the point is, the initial question is just a matter of law, and then you move on to prejudice. I agree in this case it is very much overlapping, but once again, I think that is a product of the Court of Appeals not recognizing this distinction. I mean, it's essentially, let me put it this way. If a defendant wins his Rule, or should have won his Rule 8 motion, then it's a harmless error analysis, and the burden is on us under this court's most recent, I forget, the name escapes me, but essentially harmless error prejudice burden is on us. So we have to prove lack of prejudice. But under Rule 14, the burden is always on the defendant, and he has to prove affirmative prejudice and that the jury separated, or could not separate the legal principles and facts.
But if we're under Rule 13, when the people are moving to join, then it's the people's burden to prove the lack of prejudice, right?
Well, I guess that I would move on to my next point, is that whatever the preservation requirement that this court concludes under Albu and Peterson and Barker, is that if the argument is I'm being prejudiced by this consolidation, that needs to be renewed at trial.
So I guess getting to the heart of it, why? Could you, and I'd appreciate hearing your response to Mr. Hare's argument. I mean, there is a pretty good argument that this comes out of, the old Rule 33 that required you to renew, to make a motion for new trial to preserve. Why do we have this rule? Where does Albu come from? I traced it back, and the only citation when you get to the first case was to the ABA criminal justice standards.
Well, I think that's right. It's part of it. This court adopted the ABA criminal justice standards. And
So what's the purpose for it? I mean, I frankly was trying to think of another area where we required somebody to renew a motion, and I couldn't come up with one. My concern is what Justice Boatwright alluded to. We end up in a boat, go through the whole trial, and then get a mistrial. Doesn't seem to make a lot of sense.
Well, I think that the interests are exactly what Albu said. Excuse me. You allow, this is essentially it's very similar to a 403 argument, the first of the evidentiary question. And the idea is you make the defendant say, hey, judge, you saw how this actually played out, and it was really prejudicial, and I got the short end of the stick, so I want separate trials. The second part, and I think this actually is what differentiates it from a normal evidentiary ruling, is that there are strategic questions in play here, and it is just to make sure after the trial has occurred to confirm with the defendant that he still wants separate trials.
Then why don't you have to do that with a motion in limine under 403? I agree with you, they're similar. We don't require the defendant to renew a 403 objection that they made in a motion in limine. It would seem to be exactly the same.
Well, to me, it's different in the sense of here we have a joint trial with separate charges, and so he's going to have a trial where each fund of evidence comes in no matter what. And in this situation, it was one trial. So, and I think this case is a good example. The defendant's wife's testimony related to both cases, and we can get into this in a little, but you can't have a trial in this case without talking about both cases because of what his wife testified to. So let's say you have a trial where she recants or she is just destroyed on the stand. And in that case, he really likes a joint trial because he has the best chance to walk on everything if her testimony is just destroyed. So I think it is a very small burden to make the defendant come forward and say, we just want to make sure that the defendant still wants this separate trial. And to answer your question, Justice Boatwright, I think normally it would be a mistrial. But I think in this case, let's say he had renewed and he said, and he's making the arguments he's making here today, that the Signal Mountain case shouldn't have come in through into the motorcycle case. And the court says, you know what, I think you're right, but I think the motorcycle case still goes into the Signal Mountain case. Well, in that case, you can send those charges to the jury because that's a perfectly fair trial. And then you have the trial on the motorcycle case not immediately instead of however long we are here today, 4 or 5 years later. I think that is part of it too, is that you're trying to conserve resources to, if the prejudice is so manifest and after the trial has actually occurred, you get the judge to make a ruling, and then you have that record as well to review.
I understand all of what you just said, but I guess what I struggle with is that, as a practical matter, it just seems more of a recipe for kind of a gotcha with a defense counsel who simply neglects to restate the objection at trial because there's so many other things going on when you're trying a case. And while I acknowledge that some of these strategic concerns that you've articulated may be legitimate in the abstract, I'm not so sure that there's a lot of gamesmanship that's really going on at trial with these things. It seems like more often it just gets forgotten. I'm not sure that that's really a question for you, but I guess it's a way of saying, doesn't it seem like these strategic concerns are a little overblown?
I mean, I guess my response to that is that courts throughout the country still subscribe to it as a way to save judicial resources, and at a minimum, it would make the record better.
I was going to ask you about that. What do the federal courts do? What do most of the federal courts do with these rules, or the counterparts?
As far as I can tell, I did not go circuit by circuit, but I think it's safe to say a majority of the courts say you have to renew at trial, and the consequences of that are either waiver or your objection is no longer preserved. So wouldn't go so far as to say all, but I believe a majority say you have to renew at the close of evidence or at trial sometime.
And do they do that for the same two reasons that have been advanced here, to give the judge another chance to look at the evidence now that it's come in, and to allow the defendant to reevaluate the issue of prejudice?
Yes, the same two reasons are given.
I'm going from memory here, but doesn't Federal Rule 33 still require a motion for a new trial?
I don't know the answer to that question.
Okay. I could be wrong. I just have a vague memory of having read that somewhere.
I guess one of the reasons it seems like it just gets forgotten is because having done this for many years at the trial level, I can't remember a single instance where it was renewed and the trial judge says, you know what, you're right, let's go, I'm going to sever. Can you think of an instance where that's ever occurred?
Well, I mean, we wouldn't see that.
Right, you wouldn't see it, right? Maybe it crops up somehow on appeal, I don't know. But just anecdotally, I can't think of it ever happening.
I mean, you can speak to that better than I can, but I think in the small number of cases where it would matter a lot. Because, for example, in a case like this, you could do the trial sooner. This is a huge trial, and I think that this court has adopted the standard, and the standard is still there in the ABA standards. It says you have to renew at the close of evidence, and if it's not, it's waived. They have not retreated from that.
Mr. Kozlowski, can I follow up? Just because if we were to say you don't have to renew the objection, doesn't mean that you can't. I mean, you're saying, and I see what you're saying about, in this case in particular, that maybe there would be an advantage to having it re-raised, but they could still raise it even if it isn't a requirement, right? They can
that's
still
true.
stand up and...
I mean, I think if there is any objection that is renewed, most often it's a 404B objection, because that's obviously done pre-trial, and then the defendant stands up and says,
In kind of dovetailing with Justice Gabriel's question, he's pointed out 403, we don't require it. And we don't require it on 404B either.
No, that's absolutely true, and I think that the main difference is the strategy part of that. There isn't an instance where you want 404B evidence in because it is totally extraneous to the charges. Here, you are charged with the other act, and so if the trial has gone in such a way that you are now happy with the joint trial,
But then they could still raise it and take advantage of that strategic decision.
No, they wouldn't raise it at that point. That's what I'm saying. If they brought it up and if they actually like the joint trial now, if the judge says, "Are you still standing by your severance motion?" and counsel says, "Actually, we're going to take our chances here." Well, that's an explicit waiver of the claim.
Okay.
I'm still having a little trouble with it. I mean, I can see the argument about the advantage, but is that any different from saying if the defendant moved to exclude evidence with regard to any charge and he loses, and then as the evidence comes in, he thinks he's likely to be acquitted of that charge anyway, he can't complain that the ruling was against him unless he renews it?
But I think that comes back to he's charged with the other act. I think there isn't any strategy where you, as a general matter, I'm sure you could find exceptions, where you want 404B evidence in if that act isn't charged. That can only hurt you and prejudice you. Does that answer your question?
But yes, well, sort of, we're talking about the same thing anyway. But it seems to me what you're saying is the reason we're going to force the defendant to renew is because it could be that at that point it's tactically advantageous for him to go forward with the jury deciding that
Correct.
that count. And we're not going to let him do that unless he renews. We're not going to let him rely on an earlier adverse ruling to charge error unless he renews to say he still wants to go forward. But I don't understand why that's different with regard to charges combined in this way as opposed to any separate counts. If at any point he makes a motion to exclude evidence with regard to a particular count and he loses, and then decides that evidence didn't really hurt him that much, so he'd like to have that count decided, we don't require him to renew his objection in order to assign that as error, do we?
I don't think so, but I guess maybe the answer I would give is that Rule 8 and joinder are about efficiencies. Jeez, I need to get rid of this pen.
Don't be throwing things.
Are about efficiencies, and the scales of prejudice are different, and we are gaining efficiencies by having this joint trial, and we are going to put this small burden on defendant at the end of trial to say, yes, I still believe at the end of this process that it was unfair and we should have had separate trials. I guess.
Okay, thank you.
You're going to shift to the merits?
Sure. I guess I'll shift to Rediger real fast and give you my answer on that. I think Rediger didn't alter Albu. I will say I think you have to overrule Albu. Albu says waiver. It was post rules of evidence. If you disagree with it, that's obviously your prerogative, but I don't think that it misused word. And I think the waiver in Albu is more akin to something like occurred in Cropper or Stackhouse, where it is the defendant is obviously aware of the issue because he made an objection initially, and it's more of a procedural requirement that this court has put on counsel or a defendant, and such as under Cropper, where he's deemed to know about that, and if he doesn't take action, then that is deemed to be a waiver. And let me see, going back to the distinction between Rule 8 and Rule 14.
I'm sorry.
Oh,
could-
sure.
I guess I'm not sure I'm understanding your point about Rediger and its impact here.
Well, I understood Mr. Hare's argument to be that this court has recognized that you used to say waiver when you meant forfeiture, what is now a forfeiture. And I think under decisions like Stackhouse and not Rediger and Cropper, that is still a waiver. You are deemed to have knowledge of that claim, and your decision not to re-raise it at trial is an intentional relinquishment of that right.
Okay, thank you.
As to the merits, I'm going to skip over 404B for a moment because I think the Court of Appeals dealt with that correctly, unless you have any questions about that. But even
Actually, sort of, not the 404B analysis, but, and maybe this is just where you're going, but let me just focus here.
Sure.
So if it's not, if these are not joinable under Rule 13 solely for the reason that they would be cross-admissible, what reason are they joinable for?
Okay, that's sort of where I was going, but okay. Rule 8 says you can join charges that are of the same or similar character or based on acts connected together. And I think this evidence or these charges meet both of those standards, that they are, and the Court of Appeals cases get into this a little, they are roughly similar. Even if they're not exactly similar, even to meet 404B, and the federal cases go into this, you don't have to have cross-admissible evidence to have Rule 8 satisfied. They are basically the same.
And let me just stop you right there, and because that's exactly kind of where I wanted you to you flesh out. So where you started with Rule 8 about various reasons why cases could be connected and could be charged without regard to prejudice, you started mentioning some things. Okay, maybe they're not part of the same scheme or transaction, but they're all the same store. They have all the same witnesses. The proceeds are the same. There's some reason why it makes sense to charge these and try them all at one case. But none of those things seem to be present here. The only thing that seems to be present, if I understand you guys' arguments, is these would meet the requirements for introducing other crimes evidence even if they were uncharged.
Okay, that's where I'm going. I disagree with that.
Okay.
And that goes back to my earlier comment. You cannot have a trial with each of these charges without talking about the other charges. And that is because of how the investigation proceeded and the defendant's wife coming forward. So,
I'm sorry, so I'm not, I have two questions. Is this the connected prong of Rule 8? Or, so that's one question. And question two is, why couldn't you have a different two trials with the wife testifying? I understand she testified to both, but I'm not sure why that's required. And just as an aside, I looked at Federal Rule 33. It does not require the renewal, so I apologize for misleading.
good to know.
So help me on those two questions.
So yes, I think it would be the connected together, or yes, connected together. I think they're of the same or similar character based on just how the crimes occurred. But they are connected together based on the wife's testimony and the investigation, the overlapping investigation. So the sequence of events was there are the 3 motorcycle incidents. Then the defendant confesses to the wife about those incidents. Then there is the mountain incident, and the defendant confesses to his wife about that. Then months go by, and then she eventually comes forward and says, I want to talk to the police. And the police say, okay, and they meet at a diner, and she says, the defendant confessed all of these crimes to me. And up until that point, the police had no idea who did the motorcycle cases, who was the perpetrator in those cases. So, and I urge you to read the wife's testimony. her entire explanation for why she came forward in the motorcycle case is dependent on the sequence of events of the Signal Mountain Trail. The prosecutor asked, essentially, why did you wait almost a year to come forward? And she says, I was afraid of the defendant. I was afraid he was going to do something to me. He was going to get out because he had been arrested and he was in jail. And she says, okay, well, what made you change your mind? Well, the testimony was she went to the defendant's attorney's office, and when she was in there, the attorney was taking a phone call, and she had it on speakerphone, and the DNA results came back on the Signal Mountain Trail case and said, we matched his DNA it was a little more complicated than that, but we matched his DNA. So she testified that at that point, she knew that he was sunk on the Signal Mountain Trail case, so she wasn't afraid of him, that she was confident that he was still going to be in jail. So she came forward to disclose about the motorcycle case. So I don't, even if you have a separate trial on the motorcycle case, that testimony is going to come out because he's going to challenge her credibility. And the jury is going to learn about the motorcycle case. The second reason is the letter that he wrote to her from jail. And in that letter, he says, you know about all the incidents, and an adrenaline rush was a factor in all of them. That is a confession. It was the people's position at trial. That was a confession to all the crimes in both cases. And I think a good example, a third thing, is the defendant's cross-examination of the wife. He tried to give the impression that the reason she came forward was because the police were threatening her with charges, essentially that she was obstructing the investigation into the Signal Mountain Trail case. And the only explanation for that is because he was in jail on the Signal Mountain Trail case. So they're saying she made up this thing. They gave the impression she made up the confession on the motorcycle case because she was being threatened with charges on the Signal Mountain Trail case. So the investigations of these two things cannot be talked about in isolation.
It sounds like a res gestae argument.
Yes, I would, whatever you want to call it. They were investigated by the same police, and you can't explain how he became a suspect in the motorcycle case without discussing the investigation into the Signal Mountain case.
So
it's just impossible.
Assuming the joiner requirements are met in Rule 8, and thus the consolidation under 13 was appropriate, explain why it's still not prejudicial?
For those same reasons, that the jury is going to hear about both things, and it is the explanation for both events on its face isn't a propensity inference. And I think the best, I guess I'll just use what the judge said. This is at the end of his order. It says, juries are often called upon to analyze separate charges, even as to differing charges related to the same incident, and there is nothing in the proof or the nature of the charges that would hinder or disable a jury from being able to make such a separate analysis. And I read that as, this is no different as a case where a guy robs a bank, assaults someone, steals a car, assaults a police officer, goes on a high-speed chase, and they find drugs in his car. We trust the jury to analyze all those things separately, even though it's somewhat prejudicial because it shows that the defendant does a lot of bad things at one time. Here, it was a lot of bad things over months, but on its face, we trust juries to make that distinction, and that finding is within the court's discretion.
It does seem, in the example you gave, you get close to our compulsory joinder, whether it would actually fit or not, but at least part of a crime spree or a continuous transaction. Whereas here, it seems like the thing that's in common that you're saying is the fact that he confessed to the same person. Do you think it would always be the case that if somebody confessed otherwise unrelated crimes to the same person, that they could be joined under Rule 8?
Probably not. You could probably come up with the facts where it would not be joinable. It's just that these are so intertwined, and her explanation for why she came forward was the other case.
Well, I gather Mr. Hare in response would say the facts, particularly of Signal Mountain Trail, are so egregious that you have to factor in that prejudice in evaluating whether whether the court should be forced to go to the trouble of segregating stuff in a way that would allow her to testify separately about these things. Does that make sense? So I guess what I'm asking you to do is respond to his concern about how much more egregious and prejudicial potentially the Signal Mountain Trail case is.
Well, I think the egregiousness actually helps prove the people's case in a legitimate way. He confesses to her about the Signal Mountain Trail case. In that case, we have an ID, a confession, and DNA evidence. And so then she says, and he confessed to me about these other incidents. So the inference and the argument from us is, and the prosecutor made it in closing, is you have this confession backed up by all this evidence. Why would she go over here and just make this up out of whole cloth? So I actually think that the only unfair prejudice is if they say, oh, he's a terrible person, we just think he did this. But the court considered that argument and saw that there was other evidence, him trading in his motorcycle, things like that he was confident that the jury would be able to do that fairly.
Thank you.
Thank you.
Looks like we get to see you in the next go-round, too.
Yes, I will be here again.
Mr. Hare?
May it please the court, I wanted to follow up with a discussion about Rule 8 and 13 and the state's assertion it's purely a question of law. It's a mixed question of law and fact. Again, they're seeking to divorce Rule 13, the requirement that the decision on joinder is subject to a question of prejudice. And in the counsel read from the court's order confirming joinder, you go to the conclusion and order at the bottom, the court specifically is considering prejudice in its decision to join in reference to the 404B issue that the court had explored with respect to motorcycle and the Signal Mountain Trail, and then ultimately vice versa in this particular order. And so the court understood the rules to require a consideration of prejudice before, to have the authority, if you will, to join. With respect to the judicial efficiencies, I cited to several authorities in the reply brief that talk about the customary justification for judicial efficiency evaporates when we're relying upon the same or similar character issue, because in that particular instance, which is the reason the court joined here under Rule 8, you can try both cases and try them separately, and or if you join them, you have to try both cases and try them, and there's no efficiency to joining them. But the authorities recognize that the prejudice is considerable if they're joined. I see my time has expired. Thank you, Your Honor.
Appreciate the arguments of both counsel. The case will stand submitted, and the court will be in recess for about 15 minutes. Thank you. Please be seated. Next case on our docket this morning is styled Buell v. People. It's going to be set for 1 hour. Both counsel look situated. Mr. Cox, why don't you proceed when you're ready?
Good morning. May it please the court. My name is Brian Cox, registration number 50258, and I represent Mr. Buell. The Court of Appeals in this case misconstrued the rules of criminal procedure that govern a state's motion to join cases. I'll begin by briefly overviewing the 3 rules that are implicated here, which are 13, 8, and 14. So when the prosecution moves to join cases that were separately filed, it does so under Rule 13. Rule 13 effectively directs the trial court to conduct 2 separate inquiries. First, whether the cases could have been joined under Rule 8, and also whether the consolidation would be prejudicial under Rule 14. I said first Rule 8, but really the court could go in either order because both of those prongs have to be satisfied. Now, it's interesting to note that federal cases applying the federal counterpart to Rule 13 also direct courts to consider prejudice, even though the federal Rule 13 does not include that in its text. In Colorado, on the other hand, the text of Rule 13 explicitly says subject to the provisions of Rule 14. Thus, it is as clear as can be that in Colorado, trial courts must consider prejudice before allowing cases to be consolidated. Here, however, the Court of Appeals held that it did not need to do any Rule 14 analysis. The Court of Appeals held that a Rule 8 analysis was sufficient and that based on certain loose factual similarities between the 2 cases, the same or similar criterion was satisfied and that that was the end of the inquiry. The Court of Appeals did suggest in a footnote that a cross-admissibility analysis might be required if there had been a Rule 14 motion. But Mr. Buell did not need to make a separate Rule 14 motion because Rule 13 already incorporates 14. So quite simply, the Court of Appeals got the framework wrong there. But also, on both the Rule 8 prong and on the Rule 14 prong, consolidation was not proper in this case. I'll start with the Rule 14 prong. So the Rule 14 prong requires that when consolidation would be prejudicial to the defense, that the 2 cases should not be joined or should be severed, depending on the procedural posture. Most often, the Court of Appeals has addressed that question by looking at cross-admissibility. I don't think that that's the only way that that question can be looked at, but I think that in the vast majority of cases, a cross-admissibility analysis is an important part of that prejudice inquiry, including here. So here, the 2 cases were not cross-admissible. The trial court held that they were part of a common scheme or plan, and that they would be cross-admissible on that basis. But the trial court didn't really identify any common scheme or plan. Simply doing very loosely and vaguely similar things more than once does not mean a common scheme or plan. A common scheme or plan means that there was some sort of plan that encompassed both offenses, or that one offense would logically entail the other. And there's no reason why attempting to shoplift some jewelry in August would logically or necessarily entail trying to shoplift some steaks in November. There's just nothing that really ties those 2 together. So there was no common scheme or plan, nor was there any other basis to make the 2 cross-admissible. They were not particularly close in time. Neither one shines any sort of light on the mens rea.
Mr. Cox, can I ask, don't they meet the Rule 8 same or similar standard, or do you think they do not meet that?
I think they do not meet that standard. That is a separate inquiry. The Rule 14 prejudice prong, cross-admissibility versus the Rule 8, same or similar. But I'll turn to the same or similar question. So a number of federal courts have pointed out that the same or similar is admittedly vaguely worded. But those courts have pointed out that there is not much efficiency to be gained in the same or similar context, and that the risk of prejudice is quite substantial. And so those courts, I would especially draw this court's attention to the Jawara case in the Ninth Circuit, though the Second and First Circuits have made similar comments, that same or similar should be read more narrowly. In its brief, the state relies quite a bit on a Soper case out of California, but California's rule is written differently from Colorado's, so that case does not provide any guidance to what same or similar means. I think that the Ninth Circuit case in Jawara is much more instructive. And in that case, there were two crimes that were both a type of immigration fraud. I believe one was marriage fraud. I forget what the other one was, but both were a type of immigration fraud committed by the same person a couple of years apart. And the Ninth Circuit held that that was just a vague thematic connection and that a vague thematic connection could not be enough for the same or similar criterion. I think we have a fairly similar situation here, where admittedly there is a vague thematic connection.
Isn't there more, though, Mr.? I'm sorry, I didn't mean to scare you over here. Sorry.
Please.
Don't we have more? I would agree with you, and I have some concerns about the vagueness of same or similar. But in this case, in vague or similar to me would be shoplifting. That would be a close case. But we've got here, on video, on the surveillance video, defendant goes in, Mr. Buell goes in, shoplifts, puts stuff in his clothes, walks out, gets confronted, pulls a knife, and runs away. In both of those cases, that seems a lot more than just a vague, there's shoplifting. Very similar the way he did it, the modus operandi, whether it's intent. Not to mention the fact that he didn't deny that he did it. He's on video. His argument was the legal question about whether there was a aggravated robbery at all. So help me with that.
So I do think that summary overlooks some important differences. Okay. So while it is true that in both cases he concealed merchandise within his clothing, that's a pretty common shoplifting technique, so I don't think that really narrows it down from just the broad class of shoplifting. And then beyond that, we have in the Safeway case, he actually paid for some other goods and hoped to leave having paid for those goods and not paid for others. In the Sears case, there wasn't that same thing that happened.
So help me, and maybe the best way to ask what I'm getting at is, how would you define same or similar circumstances if we had to adopt a definition? The reality is you're going to find some factual distinctions always. So, and I understand there were some here. So how would you define that term for purposes of Rule 8?
So I think you're right that there will always be some distinctions, and there will also always be some similarities. I think it's hard to articulate exactly where that line falls. I think that the Buchanan case, which came out of Massachusetts, talks about that criterion and says that it should be looked at through a lens of 404B and the kinds of similarities that are used for cross-admissibility. That would be one way to do it, and that's something that trial courts are familiar with doing. Trial courts do the SPOTO test every day, so that would certainly provide fairly easy guidance. But I think really what this court should be looking at is what is the rationale for joinder? And the rationale for joinder is generally efficiency. And in a case like this, the only efficiency that's gained is not having to do voir dire twice. There's no overlapping victims. There's little, if any, overlapping witnesses. Perhaps the police officer would have to testify both times, but his testimony was quite brief and not particularly essential to either case. So really, when you're looking at same or similar, I think that the courts should also be looking at whether it would serve the purposes of actually creating some efficiencies. So things like overlapping victims or overlapping witnesses.
Can I follow up with a question there? So you're making the argument that this simply fails the same or similar or whatever language in 8A2 without regard to prejudice.
So I think that it fails both prongs. So it fails 8A2.
With regard to the 8A argument, I understand you're arguing it would be both, but are you arguing it would fail simply by not meeting a same or similar test without regard to whether it was prejudicial.
Yes, that's correct.
If that's true, first of all, I'm not sure why one needs to do that, usually because the defendant can always make a motion to separate these based on prejudice. But if that's true, do you think, if it's simply a failure technically to meet the requirements of 8, is there a Rule 12 requirement that that kind of a motion be made within 21 days?
Sorry, that what motion be made within 21 days?
Well, I take it then you're just saying this is a defective indictment or information.
Well, the two cases were brought separately, so they were each brought in indictments that were proper. It was the joinder of them under Rule 13 that was erroneous.
I appreciate that in this case, but it seems to me you're making the argument that this fails the 8A portion of Rule 13.
Correct.
And that would be enough on its own, that it was a
Yes.
failure to comply.
Yes, either the 8A2 prong or the 14 prong are independent bases to reverse the
Let
conviction.
me ask it hypothetically so we don't get mixed up about the joinder versus. So if they had both been brought initially in the same indictment or the same information, would you believe, and the only problem was they didn't meet the requirements, as you understand them, of 8A2, would a motion have to consider that charging document defective had to have been made within the time required by Rule 12?
In that case, yes. If we were in that procedural posture where they were brought in under a single case number, single information, yes, there would have to be that motion saying that 8A2 was not satisfied. The defense also could have brought a Rule 14 motion in that situation. But this situation is different because it was the state's Rule 13 motion. And so objecting to that Rule 13 motion triggered both the 8A2 inquiry and the 14 inquiry. So back to the merits of the 8A2 inquiry. So the same or similar, in keeping with those federal cases that I mentioned, I think this court should read more narrowly than the vague thematic connection that we have here. But I think that also the problem with the state's reading of 8A2 is exemplified by the arguments that it makes under 8A2. So 8A2 has 3 separate disjunctive bases. There's same or similar, common scheme or plan, or connected together. At trial, the prosecution moved under the common scheme or plan, and I already discussed why this is not a common scheme or plan. But now in this court, the Attorney General is arguing that all 3 of those bases were satisfied, but is making essentially an identical argument for all 3. So for all 3, the state is pointing to the same general factual similarities. And those 3 bases could not have been intended to all mean the same thing. So if the exact same argument satisfies all 3, that to me means that the state is reading all 3 too broadly, and that all 3 need to be read a little more narrowly. So the third that I have not addressed yet is the connected together provision. And I think that, as came up in the previous argument, sounds a lot like res geste. So that would be one way for trial courts to apply the connected together provision using a familiar body of case law. But turning to this case, there is nothing that connected them together besides the fact that the defendant committed loosely similar crimes a few months apart. In the answer brief, the state said that the same officer was investigating both crimes. The record does not support that assertion. The record says that he was investigating Sears and Kohl's. The Kohl's incident was a guilty plea that came in as 404B, but the record does not say that he was investigating the Safeway incident. And even if he was, nothing about his testimony suggested that jointly investigating these crimes is what yielded any relevant information for either case. In the Safeway case, really the only thing that the officer would be testifying to is that he made an arrest. There was really no testimony about the investigation of the Safeway case. So that's why under all 3 provisions of 8A2, which this court reviews as a matter of law, the joinder was improper.
Could I come back to sort of because I'm kind of intrigued with your wanting to totally separate the question of whether you meet the requirements of 8A from the question whether you were prejudiced, because the defendant is entitled to a separation in either
Yes.
case under Rule 14. I guess I'm, so you would be saying, I take it then that it was not really a misjoinder, it was a question of a defective charging document, even though there's nothing prejudicial about joining the two cases together. And if that's true, why would we have a rule like that?
So, yes, even if there was no prejudice, and I very much dispute that proposition, but even if there was no prejudice, failing the 8A2 prong is sufficient for a reversal in this case, or is a sufficient reason why there was error and the trial court should not have joined the cases.
So this seems very different from the argument in your brief that 8A2 requires a 404B analysis, which seems to suggest that 8A2 encompasses a prejudice element.
Well, I think that 8A2, an easy way to apply those three bases is using case law that already exists from a cross-admissibility context. So common scheme or plan is a very familiar 404B thing. So it's very easy for courts to just use that existing 404B case law there. And connected together, like I said, closely mirrors res geste, so that's already something that exists from a cross-admissibility context. And then same or similar, I think that that Buchanan case that I pointed to talks about how 404B provides a useful framework. But it's not a framework to answer the question of whether there was prejudice. It's a framework for answering the question of whether those three, or any of those three subsections of 8A2 were met. The two inquiries do often blend together because 404B or other cross-admissibility principles are also a good way to decide if there is prejudice under 14. And so that's why the overwhelming majority of case law in the Court of Appeals decides these cases using a cross-admissibility framework.
So to that point, the Colorado Court of Appeals decision in Butson appears to formally adopt a cross-admissibility requirement in order to meet Rule 8A. Do you think that is incorrect?
So to meet 8A requiring cross-admissibility, I think that that is a very simple way for trial courts to apply the law, and that it is in keeping with the three different bases under 8A2. I would agree that the actual text of 8A2 does not say that the cases must be cross-admissible. I think it's much easier to reach that result under the Rule 14 prong. But I do think that that same body of case law provides very useful instruction for the 8A2 prong.
So then is it your position that if the court, in making that analysis, determines that the evidence is not cross-admissible, that necessarily means there is prejudice?
I think so, yes. And that's for all of the reasons that this court's 404B case law point to, all of the types of prejudice that come with other acts coming in.
Can I jump in there? In footnote 3, the Court of Appeals said that it was not foreclosing the possibility that someone might argue prejudice even under joinder pursuant to Rule 8A2. And then it said, however, here, Buell does not argue that the consolidation prejudiced him for any reason other than it allowed the prosecution to paint him as a dangerous, incorrigible, repeat offender. So, based on what you just said, it sounds like that's not the argument that was made, at least at the Court of Appeals, maybe even at the trial court level, in terms of prejudice. It wasn't that the evidence was not cross-admissible. It was just that he painted the defendant in a bad light, apparently.
So I don't think that the Court of Appeals in that footnote really did justice to either the argument in the trial court or the argument in the Court of Appeals. The question of cross-admissibility was the focus of the briefing and the argument in both the trial court and the Court of Appeals. And Mr. Buell in the trial court explicitly argued that it would be prejudicial as well. So the result of that inadmissible evidence coming into each case was that it painted Mr. Buell in a bad light. But it wasn't just sort of a nebulous idea that this is prejudicial. It was that those other acts came in that would not have come in if these were separate trials. And then some of the federal case law, the Drew case, which has been cited with approval in some other circuits since then, also talks about the fact that joinder itself also carries a certain extra amount of prejudice, that the jury's eyes will be somewhat more jaundiced against someone who's standing trial for multiple incidents at once. So in addition to the prejudice that always comes with other bad acts coming in, there's also extra prejudice from the fact that the defendant is in fact standing trial for all of these.
If I can follow up on Justice Marcus's question, I think I understood you to say if it's not cross-admissible, then it would be prejudicial. Is that
Yes.
right? All right. Is it also your position that if it's not cross-admissible, by definition, it's not a same or similar circumstance for purposes of Rule 8?
I think that that would be true most of the time. I don't know that that is true 100% of the time. There could be cases where it would fail cross-admissibility, but there are still such striking and close similarities that it would qualify under that. But under that circumstance, Rule 14 still comes into play. And I think that that's why most or virtually all of the Court of Appeals case law tackles the question from the prejudice side of the equation rather than the 8A2 side of the equation. Because if there is no cross-admissibility, then it's necessarily prejudicial.
So let me ask you a question about cross-admissibility then. For uncharged criminal misconduct to be admissible under 404B, there has to be a preliminary determination under 104A by the trial court that the evidence is such that he can find by a preponderance of the evidence that the defendant actually committed the uncharged. So do you think for two of these to have to be joined, for them have to be cross-admissible, there has to be sufficient evidence that each is proved by a preponderance of the evidence before they can be joined?
Well, I think that when the cross-admissibility comes down to a 404B analysis and that preliminary determination is required, then yes, the trial court would have to make that preliminary determination.
And if it doesn't make that, then they're not cross-admissible, which means it's prejudicial.
Correct.
Okay.
And so in that case, it fails the Rule 14 prong, and the trial court should deny consolidation. I also want to briefly address the preservation of the Rule 14 prong. So when the prosecution moves under Rule 13, that necessarily triggers both a Rule 8 analysis and a Rule 14 analysis. So I don't think that ALBU governs here. ALBU governs when the defense makes a motion to sever. But in these cases, the defense doesn't have to make any motion to sever because that rule is already automatically triggered by the prosecution's motion to join. So I did listen to the argument on whether ALBU should be overruled in the previous case. I don't think that this court actually needs to get there because ALBU does not govern this procedural posture to begin with. It would perhaps clean up the law and clarify it if this court addressed ALBU's continued validity, but I don't think that this court actually needs to go there. I think that clearly in this case, the prejudice argument was preserved. I think Justice Boatwright, you pointed out in the previous argument that defense counsel certainly could renew the objection. So if something came in that was more prejudicial than what the parties believed was going to come in based on the pretrial litigation, certainly the defense could renew that and alert the trial court to new facts that have come in that change the analysis. But if the evidence comes in basically as the parties anticipated, the trial court already knew what that evidence was going to be. The trial court already made a determination, right or wrong, about whether it would be prejudicial. It simply serves no purpose to require a defendant to re-object and say again that it's been prejudicial and request a mistrial.
Can you briefly address the abuse of discretion issue? This is sort of the same question that I put to Mr. Hare. You've made some legitimate arguments regarding the 404B analysis and why there's prejudice here, but obviously we give trial courts a lot of latitude. Why shouldn't that be dispositive in this instance, given the fact that there are some similarities, as Justice Gabriel pointed out?
So I have two answers to that. The first answer is that the Rule 8 prong is a question of law reviewed de novo. So abuse of discretion does not come in there. If the similarities or the connected together or the common scheme or plan are, as a matter of law, not there, then that's error. There is no discretion. Turning to the Rule 14 prong, it is true that that prong is reviewed for abuse of discretion. But abuse of discretion does not mean automatic affirmance. And here, particularly where the theory below was that they would be cross-admissible as a common scheme or plan, and there just was no evidence that there was any plan or any scheme that encompassed both offenses or that one offense would necessarily entail the other, that is an abuse of discretion. And on that note, I'll reserve my time if there are no other questions.
Good morning again. William Kozlowski, registration number 37824 on behalf of the people. I think it's important to remember kind of why this case ended up before this court. The case was consolidated in the trial court, came up on appeal. The defendant argued Rule 8 wasn't met because this wasn't a common plan or scheme. Essentially made the argument that he just made. And Judge Berger said, well, there's three parts of Rule 8, and the first one is same or similar character, and it already meets that. So that's satisfied. And then explicitly disagreed or said, Butson has essentially said that we need cross-admissible evidence for Rule 8 to be satisfied. And Butson said one thing, this case said the other, and here we are. And Justice Hart, I'm with you. I read his brief to say that Rule 8 meant 404B. That's what I understood his argument to be, and now he seems to be backing off that a little. So I feel like this is a law school exam where there's a bunch of terms of art and we're using them interchangeably and not being quite precise. So I'll repeat myself a little, I guess. Rule 8 is a matter of law where prejudice doesn't come into play, and it doesn't mean Rule 404B. And I think the best evidence of that, other than the plain language argument in my brief, is that other states have rules that say you can join cases if there's of the same or similar character and the evidence is cross-admissible. So, I mean, I think that's pretty good evidence that it's not part of our rule.
So you paused, you got yourself in trouble.
Sure.
Can you define for me what, again, if we're going to adopt a definition of same or similar circumstances, what should it be?
I think that's a tough question in this case, Your Honor, because I think this case meets everything in Rule 8, so it's tough to flesh that out. But I understand that this court has to write the rule. My colleague's correct that there is sort of a split in the federal courts that one talks about the class of offense and the other is, I think what it's referred to as the holistic, you kind of look at the big picture. And I guess my answer is Rule 8 it's universally held, I think, that Rule 8 should be interpreted as broadly as possible. And so my answer is essentially both. If you have 8 drug offenses, those can all be charged under Rule 8. If you have 4 drug offenses and 4 other offenses that, if you look at it from the big picture, kind of overlap and are committed in generally similar ways, I think those can be joined. So I don't really have a problem with the Jawara factors of the elements of the offenses, the temporal proximity of the acts, the likelihood of evidentiary overlap, the location of the acts, the MO, identity of the victims. I don't have a problem with that. And like I said, it's tough in this case because I think this case meets everything. But going back to the first argument, I think it's important for this court to differentiate that a Rule 8 claim is different, because then we will get cases that will define those, the limits of the rule. I think we don't have a lot of law on this because essentially defendants have made the claim, and kind of going back to the law school exam, the Court of Appeal says, well, it was cross-admissible, so it's fine. And that misses the 5 steps in between on why it's fine.
May I follow up?
Sure.
And ask, even if we, do we necessarily need to get into a definition of same or similar circumstances where the basis for joinder here was common scheme or plan?
No, not at all.
So what's the difference then, in your mind, between common scheme or plan and same or similar circumstances?
Well, I think you could have, obviously, I think under Rule 8, you're going to have a lot of overlap. But I think you can have cases where you have a common plan of, I'm going to rob the bank and then take that money and do something else, where it's not they're not the same act, but it is one plan. Or you can have a common scheme or plan, as this court and the Court of Appeals have held for a long time. If you do a generally similar crime in a similar way, you have termed that a common plan or scheme.
Well, why is that? I mean, I guess I understand common plan. You're Bonnie and Clyde. We're going to rob this series of banks. That makes sense to me. There's a plan or scheme. That there's some thought that I'm going to do this crime spree. Just because you committed similar crimes strikes me as not necessarily a common plan. Do you not see a distinction between those?
No, I mean, I see what you're saying, but this court has termed common plan to be, I think my colleague said something of roughly similar crimes, and this court just needs to look at Jones. That was admitted as a common plan or scheme under 404B, and that was 3 sex assaults, I don't want to say decades apart, but definitely years apart, that had nothing to do with one another in the sense of the defendant saying, I'm going to commit this sex assault, and then 5 years later, I'm going to commit this sex assault. Both this court and the Court of Appeals have referred to common plan as, it can be one general plan, but it can also be the same crime committed in similar circumstances.
So are you saying common plan for purposes of Rule 8 means something different from common plan for purposes of Rule 404?
No, I'm saying they mean this.
So if it's on the basis of a common plan or scheme in Rule 8, would you be saying then that that part is satisfied only if the evidence is cross-admissible?
Let me be careful here. I want to give a strong maybe to that. In my brief, I generally, as I said, I thought the defendant's position was Rule 8 means 404B. And in my brief, I have same or similar character and connected together are not 404B. Obviously, common plan or scheme is essentially 404B. But I think you could have the rare case where the issue of law under Rule 8 is met, but the evidence isn't cross-admissible because of 403, if that makes sense.
So let me put it this way then. You would be saying cases could be joined for being part of a common plan, even though the evidence of one would not be admissible as an uncharged misconduct in the other, because even though it's a common plan, it still doesn't satisfy the requirements of Part 4 with regard to relevance?
I think that is theoretically possible. I would definitely admit that it would be hard to come up with an actual real-world example of where that would be the case.
So if it were not cross-admissible because of a 403 problem, how do we get around, if we're talking about a consolidation of cases, doesn't Rule 13 incorporate a Rule 14 prejudice analysis?
Yes, absolutely. And that's,
Okay.
that gets to my point of a court can say, this can be, and it's two separate questions. This is properly joined under Rule 8, but I'm going to not consolidate it because of Rule 14. Those
Okay.
are two different things.
And so if I could follow up, so is your now interest in separating the Rule 8 problem from the Rule 14 problem of just that is what's connected versus what's prejudicial purely have to do, why would it make any difference except for your argument that if it's purely a Rule 8 problem, you don't have to renew the objection, but if it's a Rule 14 problem, then you do have to renew the objection? Is that the basis for making a distinction? Because
No,
otherwise it fails under Rule 13, doesn't it?
Yeah, but that, I guess, are you referencing just common plan or scheme? I think it can make a huge difference in same or similar character or connected together, especially same or similar character. And I think this court, the Brown case is a good example of that, where the defendant moved to consolidate and said, for cost or, you didn't want to pay for 5 trials, I want 1 trial. And I think if the people in that situation are allowed to object and say, this doesn't satisfy Rule 8, then that consolidation won't happen as a matter of law. But we don't have the 14 argument. Obviously, we wouldn't be prejudiced in that situation. So I think it's just a matter of having the 2 steps done correctly with the right analysis so that, and I said in the first argument, once the defendant has shown a Rule 8 error, that's error, and then we're in harmless error territory, we're not in Rule 14 prejudice territory, which we're talking about Jawara. Jawara says the harmless error standard is not as exacting as the Rule 14 standard. So he has a smaller hill to climb there.
Well, and as opposing counsel pointed out, it makes a big difference in terms of the standard of review as well, right?
Correct, yeah, the initial error question is de novo. So we're just arguing over multi-factor tests instead of the actual evidence admitted at trial.
So if the people in a case were moving to join pursuant to Rule 8, and the defendant wanted to oppose that motion, he could argue, number one, that the requirements of Rule 8 are not met as a legal matter, but secondly, that it would be prejudicial pursuant to Rule 14. Is that your position?
Correct. He can make two claims.
And in this case, what's your response to your opponent's argument that it sounded to me like that is what happened here, that he argued both, that there was not only a failure under Rule 8, but also that there was prejudice. I read part of the footnote from the Court of Appeals that didn't seem to think that the prejudice argument was particularly developed, but your opponent seems to disagree with that, both at the trial court level and the Court of Appeals level.
I would agree with the Court of Appeals in the sense of at the pretrial hearing, my memory of it is that he was essentially making the argument he's making here today, that the people had to show that this was a common plan under Rule 8, and they didn't. And so it shouldn't happen because of that. And even if he did make some sort of prejudice argument in the trial court, he did not make it in the Court of Appeals. The claim was, this did not satisfy Rule 8. That's why Judge Berger addressed it how he did.
And the argument was it didn't fulfill Rule 8 or meet Rule 8 because,
It wasn't a common plan.
okay, and it wasn't because of cross-admissibility.
Right, yeah, the trial court, I think you can read the order to say, he explicitly finds that it's common plan or scheme, but he also notes the striking similarity between just what occurred in general. So I think you can read it as it satisfied two parts. He essentially only challenged one on appeal, and Judge Berger said, well, we have this other one over here. So that's all I'm going to address.
Are you finished, Justice Moore?
Yes, go ahead.
So if we reach the Rule 14 issue, I gather that you disagree with his assertion that the prejudice analysis is essentially one of cross-admissibility under 404B. It's more than that, right? And I'm trying to recall what you had to say about what the more than that is.
Correct. And that's the, I relied heavily on the Soper case from California, where they essentially say the scales are different under Rule 14. If we have the joinder that is correct under Rule 8, the analysis has changed because we are gaining something in efficiency, and the usual 404B analysis of prejudice isn't the same, because one of the main things that we worry about is that the jury is going to punish the defendant for the uncharged act. Well, now that act is charged, and they have to presume him innocent, and they know he will be punished if they find him guilty. So then, and the second one is that it's unfair for him to defend against an uncharged act. Well, once again, this is a charged act, so he's going to have to defend against it sometime. So then that leaves the third of Mr. Hare said earlier, the spillover, and I think they analyzed that correctly in the sense of you have to have something of either egregiousness or maybe proof of one is strong and proof of the other is not, where we are worried that they're going to make some sort of unfair inference. And it's not just as I said before, the usual case of, if it were one case of he robs a bank and does 5 other things, we are perfectly confident that a jury can separate those things, even though he did. And this case is the perfect example. Both cases, the facts were undisputed. There was no disagreement over what happened, and it was just he made an argument to the jury that it wasn't a robbery because he already had the stuff in his pockets or under his clothes. So they were going to they heard these things that he admitted he did wrong, and it's perfectly reasonable to trust jurors to say, we are just asking you to decide whether these facts meet these elements.
Can I ask you about Rule 13 for a moment?
Rule what? I'm sorry.
13?
Sure.
So, as I understand your position, Rule 8 would allow the prosecution to file a single information or indictment in the first instance, right?
Right.
But in a case like this one, where there were 2 informations filed initially, correct? The people would move to join and did move to join pursuant to Rule 13.
Correct.
And your opponent argues that Rule 13, or he acknowledges that Rule 13 references Rule 8, but also seems to reference Rule 14. And therefore, anytime you make a motion to join under Rule 13, you're also dealing with Rule 14, and the court has to make a finding related to prejudice. What's your position on that?
I agree with that.
Okay, so you're not disputing that?
No, my only position with regard to that is that the prejudice objection has to be renewed at trial, and that goes back to the other case. But they've made this argument, this big argument that Rule 13 says Rule 14. It obviously does. My only position vis-a-vis that is that you have to renew that at trial.
Could I ask you, broadly, policy?
Sure.
Offer your thinking. Why would we want a rule that says you can't join cases that are not prejudicial?
I think the answer to that is probably set forth somewhat in the Lane case from the United States Supreme Court, that the categories that this court has put in the rule and in the similar federal rule is these are the kind of cases we are generally okay with joining, that we don't think there's too much prejudice in. So I think the answer to that question is there's always some prejudice. This is where we are comfortable, where there is, as a general policy matter, there won't be enough prejudice so we are comfortable joining them as a matter of law.
So you don't see Rule 8 as something that allows us to move forward at the beginning and prosecutors to join without having to file cases separately and then move to join them. And yet, Rule 8 inherently is subject to a separation if there's any prejudice.
That's
Under
right. I mean, I think you could come up with a lot of situations where there's no prejudice, that it's not joinable under Rule 8. A defendant could, or a prosecutor could say, hey, I've got overwhelming evidence in these 10 cases against this defendant, let's just put them all together. It's like, that may be true, there may not be prejudice, but you can't do that under Rule 8 if they're different types of charges.
Right, but wouldn't the argument be, well, it's prejudicial because you're charging me with 10 crimes and it makes me look like I'm.
No, and that, I think Judge Berger's answer to that is good, is that adheres in all cases, even under mandatory joinder. So I think, I guess maybe I'll be more clear. There are cases where you don't have Rule 14 prejudice that are not joinable, and that is a policy judgment of, here are the rules at the starting point of the general kinds of cases or charges we can bring together. And I think this is a point I meant to make in the first argument with the renewal requirement, is that you should have the same renewal requirement no matter if the cases are initially brought together or joined under Rule 13, because it is generally just a product of how the people learned that the defendant was the person who committed the crimes. Like in this case, they figured out who he was in between the two cases, so they charged the first and then they caught him after the second and they joined him. If they didn't know who he was till the end, this would have just been one case. And there probably would have been a Rule 14 motion, but there wouldn't have been the hearing on consolidation. It would have just been one case.
So let me go back to the distinction you're drawing between Rules 8 and 13. It seems to me like if the prosecution decides to join two cases together from the very beginning, then you don't have to worry about the prejudice issue, at least the way I understand your position. Unless the defendant makes a motion specifically under Rule 14. Is that right?
Yes.
But if the prosecution doesn't do that from the beginning, but then decides to do it after the two cases are filed, then at that point, prejudice is necessarily an issue because Rule 13 refers to Rule 14, right? So the difference is just when the prosecution decides to join. In one scenario, prejudice isn't of any relevance, but in the other scenario, it seems to be.
Well, I think as a practical way that this would work is that, let's say it's one case from the beginning and the defendant makes a Rule 14 motion and the court rules on it. If it's a consolidation motion, the people will make their Rule 8 argument, and I would think it'd be the rare case that the defendant says, I'm okay on prejudice. I don't have to, I'm not making any sort of argument there. And so I don't think there's going to be a situation where you don't have some sort of prejudice objection at that hearing. It's not just going to be the court doing it on its own. And I think,
But isn't there a difference on the burden of proof? In the Rule 8 scenario, where the defendant then says, move to sever under Rule 14, now it's the defendant's burden to prove prejudice. Under the Rule 13 motion, the prosecution has to prove both joinder would have been initially proper and there was no prejudice.
well, I think my answer would kind of be the same. It is hard for the people to prove lack of prejudice in a vacuum. If they say, hey, we think this is not prejudicial, and the court says, defendant, do you think it's prejudicial? And then he can make his argument on strategy or why he thinks something is particularly prejudicial. So I think and that goes kind of circles back to the renewal requirement, that the prejudice issue really is at the defendant's. I want to say the defendant's burden, but it will naturally come up from him of this is why I think it's prejudicial. And that may change at trial and goes to the renewal requirement.
So am I correct in understanding you to essentially disagree with Judge Berger's footnote 4 in the opinion where he says we do not reach whether a 404B analysis might be necessary on a motion to sever under Krempe 14 because Buell did not move to sever the cases and does not raise that argument on appeal? If I'm understanding your responses primarily to Justice Moore now, it's all at issue by virtue of 13, subsuming 14, right?
No, I think there's a lot there. My first answer is you don't need cross-admissible evidence under Rule 14.
Right.
So I think that's the first part of his statement. And then he didn't raise 14 on appeal. That's why it wasn't addressed.
Okay. That's slicing it pretty thin.
Well, I mean, I would urge the court to look at his opening brief in the Court of Appeals. The 14 isn't in there.
But you
I'm
seem
sorry.
to be, I'm sorry, go ahead.
Is 13?
I think 13 is generally there because it was consolidated, but then his main argument was Rule 8 under vis-a-vis 13.
Is it your view that in the context of a Rule 13 consolidation posture, to raise the prejudice argument, one must file a motion to sever under 14? Because that seems to be how Judge Berger was viewing it.
No, I don't think you need to file a motion to sever. I think if you object to the consolidation motion on the basis that it's prejudicial, that is all you have to do.
What he's saying here is there needs to be a separate motion to sever.
Okay, well then I would disagree with that.
And actually, you wouldn't even, I mean, you're saying that just the people moving pursuant to Rule 13 would trigger the prejudice issue because Rule 13 refers to Rule 14.
Right, and a judge can bring this up on his or her own accord. He can say, hey, I think this makes sense to join these two cases, and I'm going to because I don't think it meets Rule 8, and I don't think it's prejudicial.
And in this case, then, prejudice was at issue because the people moved to join pursuant to Rule 13, and so that means that prejudice was in play, right?
At the moment of consolidation, yes, I don't dispute.
And your position is the trial court properly addressed that, obviously.
Yeah, if I'm short on time, I mean, we argue cases a lot on similarity. You can't get too much more similar cases than this, in my estimation. They were almost exactly the same. And I think they were particularly relevant because his defense to the second incident, which was only charged as attempted robbery, was essentially, I had a knife, but I wasn't going to pull it on anybody. And the first incident, essentially, the prosecution could argue that the attempt crime was complete when he goes into that store with a knife and puts the stakes under his clothes and tries to walk out. No matter what happens after that was a substantial step that whatever the standard is, the firmness of his purpose. And the prior incident was extremely probative of that. But as I argued in the brief, his defense in this case wasn't a defense, and he was entitled to raise that as a sufficiency claim on appeal, but that failed, and this court did not grant cert on it, so he didn't have a defense to these charges.
Since you have just a little time
Sure.
left, if I could, and this question sort of drifts into the other case because I'm trying to pin you down on exactly your proposed rule on preservation. So in your view, if a defendant formally moved to sever under Rule 14, they would need to renew that motion to sever.
Correct.
And that's Albu and that case. But it's also your position that if technically it's an objection to consolidation under Rule 13, the defendant still must renew that objection and make clear that the basis of the objection is the Rule 14 prejudice.
Correct. That's my entire argument, that it is a distinction without a difference. The Rule 13 just says you can consolidate cases if Rule 8 and 14 are met. That's essentially what it says in a few words. And so if there is a renewal requirement under 14, if you made a prejudice 14 objection under 13, then that needs to be renewed because those defendants are not in a distinguishable situation.
And what if the objection is simply, I object to consolidation under Rule 13? And all of everything that it encompasses.
Then he needs to make the prejudice renewal at trial. I guess I would put it this way. There's a lot that goes into that prejudice, and there doesn't have to be 404B. I think that's the main thing, is everyone on this in the Court of Appeals is, this means 404B. And I think the federal case law that I'm asking you to look to says that's not the case. So you might have a case that meets Rule 8 without cross-admissible evidence that is not prejudicial under 14.
Thank you.
Right. Any other questions? Thank you, Your Honors.
Thank you. Rebuttal?
So I think, Your Honors, when we're talking about what was or was not raised below,
Sorry, could I stop you for a moment? We need to, the clock.
We have the clock going.
Thank you.
so when we're talking about what was or was not presented below, I think it's important that we look at specifically how the prosecution went about moving to join these cases by saying that they are a common scheme or plan. So common scheme or plan under Rule 8, common scheme or plan is also something that comes from 404B case law, and that all of the case law that was relied on in the prosecution's motion, all of the argument was really about whether this would satisfy 404B. And that is also a way of arguing that it would be prejudicial if they were not cross-admissible under 404B. So naturally, the arguments overlapped. But the arguments did encompass both the 8A2 prong and the 14 prong, and so this court should look at both. In terms of the requirement to renew the objection, again, I think that if unexpected evidence comes up that gives the defense a reason to re-raise it, then that's perfectly valid. But when the evidence that came in is the exact same evidence that was in the prosecution's motion, that was argued at the hearing, that the court already decided would not be unduly prejudicial, no one benefits from giving the court an opportunity to revisit that when no facts have changed. But even if this court disagrees, if this court holds that it does need to be renewed, at the time of trial, Mr. Buell was relying on the Court of Appeals opinion in Gross, which said that in this exact procedural posture, there was no renewal requirement. And so out of due process concerns, Mr. Buell would ask this court not to apply that renewal requirement retroactively. If there are no other questions, Mr. Buell asks this court to reverse the Court of Appeals. Thank you.
Thank you. I appreciate the arguments of both counsel. The court will be in recess until After lunch.